So Taylor and Johnson, this is a case too that's worth actually having a look at the facts, because it will deal with mistake in advance contract law, but I noted on the kind of issues that come up, can somebody be bound by an offer if they've misunderstood it? So this is a case where Mrs. Johnson had two adjoining lots of land. They were both about 5 acres, and the value of that land at the time was about $50,000, but it was going to jump because of some rezoning. And this is back in 1975, so it's a relatively recent case. Mrs. Johnson gave an option to Mr. Taylor to purchase the land for a total price of $15,000. Now, he knew about the rezoning, and he also knew about the potential for the value increase, but he didn't tell her. So he exercised the option. Subsequently, both he and Mrs. Johnson passed away. So this is actually a fight between the two estates, between the children. Now there were two kind of problems. One is there was a deceit element, because Mr. Taylor knew that the value of the land was likely to jump and he hadn't told her. But the other was there was a mistake element. She understood that it was $15,000 an acre, and so she'd get about $150,000, and he knew that there was a mistake in the document, and he knew that she had misunderstood, and the document talked about $15,000. So the Taylor children sued for specific performance. So remember on Saturday we talked about equitable remedies, so they sued in equity because damages, getting the deposit back or the money back from that their father had spent already, wasn't going to address their loss. They wanted the land because the $15,000 that's now worth, $195,000, that's a big profit for them. And the issue before the court was whether there was an agreement or whether the mistake vitiated her acceptance. So vitiate here means like pulled it away, meant that her acceptance was meaningless. And the court held that it is not the subjective beliefs or understandings of the parties about their rights or liabilities that govern their contractual relationship. What matters is what the party by words and conduct would have led a reasonable person in the position of the other party to believe. In other words, the fact that the document had a mistake in it that she wasn't aware of, that doesn't matter. A reasonable person looking at it objectively would believe that that piece of paper was their agreement and her mistake wasn't relevant. Now, it wasn't all terrible for Mrs. Johnson's family because of the other point, because of the deception. Ultimately, her children won out. But on this contract law point, we use an objective test.